Hi, this is Kip from Malek. So I had a video about somebody getting bit at the Akron Zoo by a Komodo dragon, and I just thought that was kind of a wacky work injury that you could be involved in. Just as an aside, when I was a kid, one of my dreams or wishes was to get a iguana, and my dad and mom, they didn't allow me to get an iguana, but anyways, I could get bit by a Komodo dragon at the Akron Zoo, I guess. So the interesting thing is, and as I said in that short, yeah, you can apply for work injury as a result of a Komodo dragon bite if it's in the course of and arising out of employment as an Akron Zoo employee. And I want to look at different scenarios when a Komodo dragon bite may or may not be a compensable workers' comp claim, just because I think that's a wacky fact pattern. But so what happens if you're a goofball and you go into the cage and you're just not paying attention to where the Komodo dragon is? You go in the Komodo dragon's cage and he's chomping away at some slab of beef, and you're just super careless, and then you get attacked by the Komodo dragon. And one could say, hey, this guy's a goofball, he's negligent, and his own negligence caused him to be bit by the Komodo dragon. So could you file for a compensable workers' comp claim, and would it be allowed? Again, if it happened in the course of arising out of the work, yes, it would be. And you would, in the argument, you might say as well, what about the fact that you were negligent? You're a goofball and you're jumping into the cage when the dragon's eating the slab of beef. The answer to that would be workers' comp doesn't consider negligence, either negligence on the part of the employee or the part of employer. So that's not considered, so it would be a compensable claim. So what about this scenario? What if you and your coworker have like a game, and the game is, hey, I dare you to run into the Komodo dragon's cage and then go to touch the wall and then run back out and see if you could do that. And if you could do that, I'll give you $10. And so you're like, cool, that sounds like a fun thing to do. And so you run into the Komodo dragon's cage, you tap the wall, and as you're coming back, you're bit by the Komodo dragon. So would that be a compensable workers' comp claim? It may be, but an argument by the employer would say, and if they get, witness statements from your coworker buddy who put you up to this scheme, the issue might be you're involved with horseplay, so that would be a defense. And if the industrial commission, if the employer argued that, the industrial commission may find that it was in fact horseplay, and then it may be denied. So that's another, in that instance, it might not be allowed. What if the weekend before you go to work, you smoke marijuana or weed, and then you go into work, and as you're doing your tasks in the Komodo dragon cage, Komodo dragon bites you, the employer does a post-accident drug screen, and because that's often what they do, and in that post-accident drug screen, it turns up, oh, you got marijuana in your system. So the issue in that instance would be if you tested past a certain limit of marijuana, then the rebuttal presumption may come into play that the marijuana or weed was the cause of the work injury. So in that case, it's a rebuttable presumption. You could rebut it by presenting arguments and evidence that you weren't intoxicated or impaired by the weed. Otherwise, if the presumption didn't kick in, then the employer may argue, well, this person had weed in their system and they're acting loopy, and if they might get witness statements that say you're acting loopy, and it may get denied. But on the other hand, you might argue, hey, I have weed in my system. Doesn't mean anything. The recreational weed's legal at this point. There's no witnesses that can say that I was acting in impaired manner. It just so happens that I had smoked weed over the weekend, and I got bit, because Komodo dragons bite people, I guess. So in that instance, you may, it may be allowed. It just really depends. But believe it or not, this situation, we encounter this quite often, and it's, these things, claims get allowed just because you have weed in your system. You just have weed in your system. I mean, sometimes folks have poly-positive drug screens and they still get their claims allowed. And it's really a factual thing. Obviously, you don't want to be, you really, really do not want to be doing drugs. Like, you don't want to be doing multiple different kind of drugs and working in certain industries. And if you are, you're really kind of, you're going to risk a situation where you get injured really, really bad, and then your claim's denied because, again, you have a poly-positive drug screen or even weed. So you got to really make a decision. You got to look at that. Is it worth that risk? But anyways, in that situation, the claim may or may not be allowed. So let's imagine that for some reason, Ohio happens to be in Indonesia, because, hey, why not? We're thinking about this. And instead of 6 months of winter, we have 12 months of warmth. And it just so happens you are parking at the Akron Zoo, which happens to be in Ohio in the middle of Indonesia. And as you're walking in the parking lot, you park your car, you're walking in the parking lot, you haven't clocked in, you're walking to the entrance of the Akron Zoo, and, lo and behold, a Komodo dragon, it's a wild Komodo dragon, in fact, comes and bites you, and you file a workers' comp claim. Would that be allowed? So generally, the general rule, remember, the going and coming rule says that injuries that happen while you're going to work or from work are not compensable. That's called the going and coming rule. That's the general rule, but there are exceptions to that, and one of the exceptions is the zone of employment. So generally speaking, the ingress and egress to your job, so the parking lot, the sidewalk, if it could be shown that the employer has possession or control of that area, they don't have to own the parking lot, but if it's shown that everybody's parking in this particular parking lot and they have to go from the parking lot to the store, or in this case, the Akron Zoo, then you could say the zone of employment applies, and therefore, even though generally speaking, it would be denied, it happened in the zone of employment. And the reason why you're there is because you're there getting ready to check into work. And they look into other factors too, the proximity, control, and the benefit of you being at that location. Proximity, you're in the parking lot. Control, the employer, generally speaking, has possession or control of the parking lot. And then the benefit to the employer, well, you're going to work to perform labor, i.e., zookeeper or whatever at the Akron Zoo. So in that instance, yes, it would be a commensable claim. So what happens, and this is simple, but what happens if you are stepping out of your house and you're in Ohio, in this example, which happens to be in Indonesia, and there's a wild Komodo dragon, it bites you, and you're stepping from your house, you're walking your car, and it bites you, would that be a compensable claim? Well, in that instance, the going and coming rule would apply, and it wouldn't be compensable because, you're going to and from work. So in that instance, you're going to work, and if you're gonna, again, look at that proximity, benefit, and control, proximity, your house is probably nowhere near, the zoo. And then control, the employer has no control over your house or the area around your house. And the benefit, I don't know, you could make a really, really attenuated argument that there's a benefit, from going from your house to your car and then to work. But that's a benefit that everybody does. And generally speaking, Ohio, and most states for that matter, with this have a going and coming rule type situation, they don't want to put that risk on employers, and to a certain extent I think that's reasonable, because they don't want to put the risk of getting an injury like driving on the highway on employers, because that's a risk that everybody faces. So in that instance, the bite by the Komodo dragon in your own yard would not be compensable. So it's kind of an interesting little hypothetical. And again, I just thought it was kind of a crazy fact or news bit that this person was, you know, in the Akron Zoo on March 3rd, 2024, was actually bit by Komodo dragon in Ohio. And I thought it'd be interesting to analyze hypotheticals using the Komodo dragon. So you've been listening to Kip from Malek and Malek. As I say in all these videos at the end, workers' comp in Ohio is a incredibly complicated beast. I highly recommend that you almost must always get an attorney involved with your workers' comp claim. If you don't, you're really kind of setting yourself for heartache. So ask your friends, your coworkers, your relatives, your brothers and sisters, mom, dad. Ask them for who they use for their workers' comp claims, or who they recommend, and call that attorney. Otherwise, go search on Google. Anybody who's advertising for workers' comp work likely has been in that game for years, and so they're going to be competent. But I do always recommend that folks, if they have a work injury in Ohio, get a workers' comp attorney. And also, you know, when you call these workers' comp attorneys, one, you're not going to have to pay to just discuss your case, and then two, you know, I would talk to multiple folks and go with that attorney that you vibe with, that you like best, and so don't feel compelled to have to sign up with the first person that you call. So anyways, Kip from Malek and Malek. Thanks for watching this video, and stay safe.